Hi, I'm Darcel Lobo. I own Dow Law Firm in Normandy Park, and today we're talking about if you can avoid probate in Washington State. And the short answer is yes. If that was the question and you wanted a yes or no answer, the answer is yes. If you want some more details about how and why and what to do, then let's get into that. So let's start off with what is probate. Probate is a process whereby a court oversees the administration of someone's estate, whether they have, a will, or if they don't have an estate plan at all, no will, no trust, no anything. The court's going to oversee to ensure that the estate is distributed according to the terms of what state law says, or if there is a will, then according to the terms of what the will says. And there's confusion with this sometimes. Sometimes people think, well, I have a will, so I won't need probate. That's not correct. Okay. A will is a set of instructions of what you want to have happen to your estate after you passed away. But in order for it to happen, it needs to be admitted to probate. Probate needs to be opened for the court to oversee the distribution of all of your assets, the payments of your debts, and distributions to heirs according to the terms of your will. But there are some ways around this. Okay, so let's get into what those are. And I will say that probate can be different state by state across the U.S. So here in Washington State, probate is more streamlined, more efficient, and not as expensive as in other states. I know I've heard notoriously that California is a state where people do not want probate. Given the time and the cost, I believe the cost is like a percentage of the estate. We don't do that in Washington. So if you've heard that before, if you've seen that online, you've Googled that, or you know someone who may be from California or had experience with probate in California, you may be hearing that, but that's not how it's done in Washington. Okay, so let's talk about some ways that you can avoid probate in Washington if you do want to avoid probate. A revocable living trust. That is usually the key way how a lot of my clients elect to avoid probate. You create the trust now, you put your assets into the trust now, you are the trustee of your own trust during your lifetime, so you can control your assets just as you do now. But upon your passing, you've named someone as your successor trustee who steps in, takes over the assets, and distributes them according to the terms of your trust. So the trust says everything gets split, between my son and my daughter 50-50. The trustee will do that, not have to go through probate, not have probate court involved in that. They're able to just do so outright as your successor trustee. In order for the trust to work, it has to actually own the assets. So when we create your trust for you, we will fund, it's called funding your trust. We will fund your trust with your real estate that you own, put your personal property into your trust with your personal property assignment, talk to you about naming the trust as beneficiary or account holder of financial accounts and various financial, investments, things like that. So we'll talk about all that when we do your estate planning. So a revocable living trust is kind of the biggest way that, what we use to help clients who want to get their estate plan in place and want to avoid probate. Another way is that if you own property joint with right of survivorship, that means that that property will pass automatically to the other co-owner. So let's say you own a home. And I talked about this recently in another video, so I'll try to make sure it's linked down below for you, if I remember. If not, it's in the recent history talking about joint ownership. But with joint ownership with right of survivorship, that means, let's say that you bought a home with someone else. Let's say you and a friend bought a home together. You bought it 50-50. If you own that home, and if the deed says that you own it jointly with right of survivorship, that means upon you passing, your 50% interest would go to the survivor of you automatically, and vice versa. If they passed away, their 50% would go to you if you own the property joint with right of survivorship. Okay, so that's another way to avoid probate, is for that asset to pass to that survivor of you. And if you could have 3 people on title, you could have 4 people on title, it doesn't matter, but it would pass automatically if the deed is set up joint with right of survivorship. You can also do this for a lot of your financial accounts, like a checking account or a savings account. You can add someone onto your account to be a joint account holder with right of survivorship. So upon you passing, that asset, that account would go to the survivor of you automatically, and it would avoid probate. Another way for real estate here in Washington State specifically, other states have this option as well, but I'm just focused on Washington because I'm only licensed to practice in Washington, is a transfer on death deed. So a transfer on death deed is where you name a beneficiary to real estate. So let's say you own a home and you want that property to go to your adult child, and it's just a one adult child. We can prepare a transfer on death deed where we name that adult child as the beneficiary of that property. And so that upon your passing, that real estate can transfer to them without having to go through probate. That transfer on death deed is fully revocable, so if you want to change it during your lifetime, you can do so. Upon your passing, it goes to the person that you've named. Along those same lines is beneficiary designations. So for all of your financial accounts, you should be able to name someone as a beneficiary. And so if you do so upon your passing, that account will go to whoever you have named as beneficiary. Here's the one thing about beneficiary that I will say about this, is that you may have opened an account 20, 30 years ago, especially if it's a retirement plan through work or a life insurance policy, and you name someone as beneficiary, but you haven't looked at that or reevaluated that since you set it up. And the person that you named 20 or 30 years ago may not be the same person now that you want to receive that asset. So you have to please ensure that you are updating your beneficiaries as there's life events, if there's births, there's deaths, there's marriages, there's divorces. Please ensure that you are updating those beneficiary designations. And a lot of institutions will allow you to name more than one person. So if you have 2 kids or 3 kids and you want to name both of them equally or the 3 of them equally, you should be able to do so. Talk to the institution about what limitations they may have on the beneficiary designations, or sometimes you can do someone as primary beneficiary and somebody else as secondary beneficiary. So make sure you understand what options are available to you and that you are updating those beneficiary designations as, life happens, life changes, and you want to change who receives it. Make sure that those are updated as well. Please do not name a minor as your beneficiary. If there's any takeaway from this, please let it be this. Do not name a minor as a beneficiary of anything, okay? Under Washington state law, they are not competent to inherit something. So there's going to be a whole lot of court involvement, most likely, if you've named a minor. So please do not do that. All right, enough about beneficiaries. Next option. If somebody has already passed away and they have what Washington state determines is a small estate, that is an actual term, a legal term that we use. If they had a will or they didn't have a will, if their estate qualifies as a small estate, you should, if I could make a little asterisk sign, I would do that right now. You should be able to use the small estate affidavit to collect those assets. So to qualify for a small estate, there cannot be any real estate as part of the estate, and the value of assets has to be under $100,000. If you meet those 2 criteria, you should, again with an asterisk, be able to collect those assets if you are the rightful heir to those assets with the small estate affidavit. Now, why am I saying should? Why do I have this caveat with that? Because this process is Washington state specific. And a lot of these bigger banks are national banks. and are not as familiar, or they pretend to not be as familiar, I'm not sure which it is, with the small estate affidavit. So I have unfortunately had many clients where the estate qualified as a small estate affidavit, as a small estate, and should have been able to use the small estate affidavit, but the bank will not process it. The bank says, no, we need letters testamentary. And you can go back and forth and back and forth and back and forth with them, and they still come back and say they need letters testamentary. So sometimes I can get involved, write a letter explaining what the law is, why the bank is wrong, why they need to release the funds, cite the statute in Washington State for small estates, and hopefully get it released. The amount of time and the back and forth and all the delays, for a lot of clients, it's just more efficient to just open the probate, to just have me open the probate, which is unfortunate because they don't have to. They shouldn't have to. But the bank isn't releasing the funds without letters testamentary. So the small estate affidavit process is an option if the estate is a small estate. However, just know that you may encounter, especially with your bigger banks, your national banks, your Bank Americas, your U.S. banks, like, I'm going to call them out. I have experienced firsthand where they will not process these, and they will refuse to do so, and they demand letters testamentary even though they are wrong. So those are kind of the options. So let's see, we went over trust, we went over joint ownership with right of survivorship, we went over transfer on death deeds, we went over beneficiary designations, we went over a small estate affidavit. So those are kind of the main ways in which you can avoid probate here in Washington State. Again, probate in Washington State is really not as bad as you may have heard as in other states. But for some clients, they don't want their family or loved ones or friends to go through probate. And aside from going through probate, which is a court process, they also don't like the idea that probate is public record. So your will, the probate, what your assets were, what your debts were, how much your heirs received, that all is public record, and sometimes clients just don't like that. They want more privacy. And so those are the options to avoid probate, kind of how you would do so, when you would use these different options. So if you need help with your estate planning, we'd be happy to help you. Again, I'm the owner of Dow Law Firm. I am Darcel Lobo. I am an attorney. Feel free to reach out and give us a call or text at 206-408-8158, or you can visit us online at dowlawfirm.com, and I'll have all that below for you. And if I remember, I will also link the videos that I've referenced during this video for you to check out also if you want to do so. So, all right, I hope this helps, and I'll see you in the next one. All right, bye.